My lords, ladies and gentlemen, welcome to the 2013 University of Essex Clifford Chance lecture. Andrew Phillips, otherwise known as Lord Phillips of Sudbury, otherwise known as Radio 2's Legal Eagle, and more particularly known as Chancellor of the University of Essex, can't be with you tonight, so I'm here to accept the award as Best Supporting Chairman, and I hope you'll go easily with me in that regard. We'd only, of course, accept one excuse from Andrew for his failure to turn up, and that's that he's doing something legal. He's doing something very legal. He's making law in the upper house. I don't know what kind of law, but I'm sure it's something that would have the support of the Human Rights Department at the University of Essex. So we'll hold him to account on that regard. Tonight's subject is of no small importance. It's about the meaning of terrorism. It strikes me as a citizen and a one-time practicing lawyer that it's a word that's perhaps become totally attenuated and not obviously devoid of much content these days. For me, as a schoolboy growing up in Belfast in the early 70s, it had a very visceral and non-technical meaning. And one might not know how to describe it, but one knew it when one saw it. Tony Blair, as Prime Minister at the end of 2001, said that the rules of the game in relation to terrorism had changed. Not sure he was ever thoroughly interrogated as to what that meant at the time. Maybe we know now, maybe we don't. The geographic areas of perceived threat have changed over the last 30 to 40 years, and the legislation has kept on coming. Those of you who will know that in the period since I was a partner here, I do different things in my life. My most notorious role is as a member of a much misunderstood body, the Press Complaints Commission. And we had a recent complaint about the extent to which it was misleading for a well-known national newspaper title to describe the Regulation of Investigatory Powers Act as a piece of anti-terror legislation. Plainly, it suits one media agenda to assert that that act, which is perceived by some journalists to curtail and inhibit their investigative activities, is actually meant for other people, real grown-up crooks, otherwise labelled as terrorists. Well, perhaps all these issues will be illuminated in the speech to come. We are particularly fortunate to have tonight as our speaker David Anderson. I know the bar is very coy about league tables and public recognition, unlike the rest of us who set great store by these things, but I think it's fair to say that our speaker, whilst enjoying a luminous career at the top end of the English bar, also holds the accolade of having appeared more times at Strasbourg than any other lawyer. I dare say I'm not going to be challenged when saying that tonight, because he is, of course, David Anderson, and David is that rare combination of an advocate who's equally at home in cases involving English domestic judicial review, Strasbourg, ECHR, human rights points, and hardcore commercial ECJ challenges. I would know because over the years I sought his advice on all those areas, and in circumstances where all those jurisdictions are coming together, that's plainly a valuable skill to have, to be equally expert in all those areas. But in addition to his existence at the bar, he was appointed last year the government's independent reviewer of terrorism legislation. It's an important role. It concerns all of us. He is, as I would see it, he may disagree. It seems to me he's doing an important job for us. And David, we look very much forward to hearing from you now in that regard.
Well, thank you, Michael, for those delightful untruths. My wife was a student of the University of Essex, and she then taught there for 5 years. But this is the first time I've had the opportunity to address members of the university. I'm very grateful for the invitation. 16 years ago, on the 9th of February, just across South Quay from here, the IRA ended a 2-year ceasefire by giving 90 minutes warning of a bomb, which killed 2 people in the newsagents opposite, wounded 39, and caused more than £100 million worth of damage. A few days later, a smaller bomb went off prematurely, killing its bearer and destroying a bus on Aldwych, a similar distance from my own chambers. They were followed during the football tournament, Euro '96, by the biggest peacetime explosion England has ever seen. The bomb injured 200 people and flattened £700 million worth of Manchester city centre, the remarkable exception being the Victorian pillar box, standing no more than 5 metres from the bomb itself, which survived unscathed and is still there today. It's got a little plaque on it. And 15 deaths were caused that year by the security situation in Northern Ireland, to add to the approximately 3,500 such deaths over the previous 28 years. Further afield, the same year saw 90 killed and 1,400 injured in a single Sri Lankan bomb, at least 6 hijackings, one of them diverted to Stansted, a suicide bomb campaign in Israel, the Olympic Park bombing in Atlanta, which wounded more than 100 people but failed to achieve the cancellation of the Games, and the Khobar Towers bombing in Saudi Arabia, injuring 500 and killing 19 US servicemen. That year was not unusually violent. Indeed, the number of terrorist attacks globally was assessed by the US Department of State as the lowest for 25 years. There were not the frequent hijackings of the early 1970s or the embassy hostage takings that were prevalent 10 years after that. So why do I single out 1996? Because 1996 is the year in which a report was written by the distinguished law lord, Lord Lloyd of Berwick, with the expert assistance of Professor Paul Wilkinson. The purpose of the report, commissioned by the Home Secretary and the Secretary of State for Northern Ireland, was to advise the government whether the United Kingdom needed a permanent anti-terrorism law to replace the temporary statutes applicable largely to Northern Ireland, which had been subject to annual parliamentary renewal since, in some cases, 1974. As we have seen, this report was written not in some prelapsarian age of terroristic innocence, but rather at a time when both international terrorism and Northern Ireland-related terrorism, as they are now referred to, were very much a fact of life on this island. Nor was any improvement being counted upon. Lord Lloyd, advised by Professor Wilkinson, warned of what he called the worrying trend towards the use by terrorists of more and more deadly methods, noted that the hijacking of aircraft has given way to their destruction in mid-air, and drew attention to what he called the spectre of the possible use by terrorists of nuclear, chemical and biological materials, a risk fresh in his mind after the deadly sarin gas attack on the Tokyo subway in the previous year, which put 5,000 people in hospital, but one which since then has thankfully, and perhaps surprisingly, remained more spectral than real. Lord Lloyd advised that a permanent law was needed. First the government and then Parliament agreed, taking his report as a template for the comprehensive code of anti-terrorism legislation that, after careful debate, turned into the 7 parts, 16 schedules and more than 300 pages of the Terrorism Act 2000. Much of what became the 2000 Act was taken from the Northern Irish legislation and given general application. Other elements were new. The 2000 Act was, or appeared to be, a comprehensive code. In the following year, the Home Affairs Select Committee remarked that this country has more anti-terrorist legislation on its statute books than almost any other developed democracy. But it did so as it began its consideration of another bill, prompted this time by the attacks of 9/11. Today, the Act of 2000 has many new and unpredicted companions. In particular, the Anti-Terrorism, Crime and Security Act 2001, passed in the weeks after 9/11, the Criminal Justice International Cooperation Act 2003, the Prevention of Terrorism Act 2005, the Terrorism Act 2006, giving effect to Tony Blair's declaration that Michael mentioned shortly after the London attacks of 7/7, that the rules of the game have changed, the Counter-Terrorism Act 2008, the Terrorist Asset Freezing Act 2010, the Terrorist Prevention and Investigation Measures Act 2011, and the Protection of Freedoms Act 2012, though the last three, as we shall see, begin to reverse somewhat the direction of travel. More than 12 years on, we might ask whether, and if so, why, this bewildering range of terrorism-specific powers is considered necessary, particularly those added after the clear-sighted assessment of risk and the careful thought that lay behind the Terrorism Act 2000. The case for special terrorism powers, I would suggest, should be approached with a measure of scepticism. Many advanced countries managed until recently without special terrorism laws of any kind. And the terror label, evocative as it is, risks distorting anything to which it is attached by its sheer emotional power. Terrorism stands for everything that is extreme, dangerous, frightening, and secret, qualities which render it glamorous to all who associate with it. Seasoned criminals in Northern Ireland, chiefly concerned with enriching themselves by the smuggling of tobacco or of red diesel, may profit from the status of terrorist to improve their standing in the sub-communities of sympathisers, thankfully now small and local ones, to which they belong. Young British Muslims travel to lawless parts of the world, seduced as young men have always been by the certainties of strong belief and the romance of hardship, comradeship, and conflict. Terrorism can make the careers of politicians, police officers, lawyers, and academics. It swells the budgets of military, intelligence, security, and police forces, publishers, and film studios. The police officer transferred to a counter-terrorism unit can walk a bit taller. The provider of security fences, or CCTV, can profit from the stardust that comes from appearing with 400 other exhibitors and 8,000 delegates at an operationally critical two-day event. It's in London in April. Even a humble reviewer of the law may, if he is lucky, be given a distinguished platform such as this, and by dropping the word into his lecture title, as have 3 of the past 8 Clifford Chance lecturers, may hope to attract an equally distinguished audience. I see 2 of them are sitting in that distinguished audience. All these people are, by the mere use of the T word, taken out of the normal vocabulary of crime, government, or commerce into a mental space that is inhabited by Robespierre, Irish dynamiters, Russian anarchists, Olympic hostage-takers, mujahideen, desert bandits, and on the other side of the fence, special branch, undercover agents, Navy SEALs, and drones. There are all sorts of mutually reinforcing relationships here, the strongest being between the terrorists themselves, who rely on publicity to promote fear, and the media, which knows from experience that there is no better word than terror with which to invigorate a front page. Indeed, the word has such magnetic qualities that ordinary compasses are not to be trusted anywhere near it. I sometimes wish it had never found its way into the law. For our more sober purposes, something more prosaic, politically motivated violent crime, perhaps, might have been more suitable. But it's too late for that. The concept is now considered to be a legal one, for better or worse. We need to shield our compasses and try to work out what the justification for all those special laws might be. May I suggest 4 commonly advanced justifications? There is something in most of them but none of them takes us all the way there. The first is the suggestion that terrorism is a uniquely great threat to our lives and well-being. The shadow of the 9/11 attacks, with their 2,800 dead, is inescapable. Nor will we ever forget the 52 killed and almost 800 injured in the 7/7 attacks, or the 3,500 killed over the 30 years of the Troubles in Northern Ireland. In the first two cases, the horror was increased, as the perpetrators intended, by the collective impact of all those simultaneous deaths, and in the third, by the long period over which the threat persisted. I mean no disrespect to those victims or to their relatives when I point out that 180,000 Americans have been murdered other than by terrorists in the years since 9/11, and that the 7/7 victims remain the only people ever to have been killed by Al-Qaeda-inspired terrorism on United Kingdom soil. That nothing worse has happened since has at least something to do with the tireless work of the intelligence services, for it is undoubtedly true, as the Director General of MI5 said in a rare public speech last year, that Britain has experienced a credible terrorist attack plot about once a year since 9/11. But despicable as these major attacks were, all were criminal acts under the ordinary law. Their existence and the public reaction to them cannot, of itself, justify the tearing up of long-standing freedoms and protections. Some more specific deficiency in the law needs to be identified. The second reason, sometimes heard for the special status of terrorism in our law, is that it poses an existential threat. It is quite true that in the weeks after 9/11, the United Kingdom declared the existence of a public emergency threatening the life of the nation as a justification for derogating from Article 5 of the European Convention of Human Rights, as indeed both the United Kingdom and Ireland had done in the past in relation to the Northern Irish conflict. I was over at the Council of Europe with a monitoring team when the news came through, and I remember the sense of shock and disappointment. What will happen when other states follow suit? But not one of the other 40-odd members did. Our government's judgment on this matter was respected both by our courts, though with the dissent of Lord Hoffman and with what Lord Bingham has described as varying degrees of enthusiasm among his colleagues, and in Strasbourg. Whether the government continues to assert that we face an emergency threatening the life of the nation, I am not sure. The point will only arise for decision if and when we once more seek to derogate from the Convention. But no such derogating laws are currently in force. It is not, I think, suggested that the general run of anti-terrorism laws is justified only in the case of a public emergency or a threat to the nation's life. A permanent emergency would be a contradiction in terms. Permanent anti-terrorism law, as we have seen since 2000, is not. The third reason, sometimes advanced, is that only the terror label will do to mark public revulsion at a particularly unpleasant offence. This one, I think we can say, has been disproved by experience. James McArdle, the South Key bomber, was charged with murder and convicted of conspiracy to cause explosions. The 4 men whose rucksacks failed to explode in London 2 weeks after the 7/7 bomb were convicted of conspiracy to murder, as were the 8 men accused of the airline liquid bomb plot of 2006. That plot was described by one of the 3 trial judges as the most grave and wicked conspiracy ever proved within the jurisdiction. It is the origin of the continuing requirement to empty your water bottle before you get on a plane. In none of those cases was it suggested that a specialist terrorist offence would have more effectively marked the public mood. Indeed, convictions for the specialist offences tend to be reserved, as we shall see, for plots detected at an earlier stage or for those whose involvement in terrorism is more peripheral. What, finally, of the argument that specialist laws are justified by the existence of Al-Qaeda, the paradigm of the so-called new terrorism, characterized by transnational networks, suicide bombers who strike without warning, and the deliberate causing of mass civilian casualties? Well, the Al-Qaeda franchise has been unique in terms of the number of countries from which its adherents have been drawn, the number of countries in which it has launched attacks, and the ambition of some of its adherents to establish a pan-Islamic or even global caliphate, however absurd and impracticable that might seem. Transnational networks are indeed a function of modern Islamist terrorism, as they are of almost every other aspect of modern life. Just as with cross-border fraud or organised crime, they require an enhanced international response. But they have not been unknown in the past. The Fenian bombing campaign in London of the 1880s depended upon its foreign training camp, the Brooklyn Dynamite School, and the propaganda produced under First Amendment freedoms, including that notable New York periodical, Ireland's Liberator and Dynamite Monthly. And the identification of religiously inspired plotters with foreign powers and foreign training goes further back than that. Several of the gunpowder plotters were educated by foreign Jesuits, while the explosives expert Guy Fawkes was recruited for the task in Flanders, where he had learned his skills as a mercenary, originally for the same King of Spain, Philip II, who had recently launched the Spanish Armada. Suicide attacks are currently common in Afghanistan, Pakistan and Iraq, but they have a long history in warfare, have accounted for many world leaders in the past, including Alexander II of Russia in 1881, the Tsar who freed the serfs, and they were much practiced during the late 20th century in the Lebanese Civil War and by the Tamil Tigers. Al-Qaeda operators tend not to subscribe to the classic aim of terrorism, famously described as a lot of people watching, not a lot of people dead. They have never restricted themselves to national security targets, as is currently the practice of dissident Republicans in Northern Ireland. But they were certainly not the first to aim for mass civilian casualties, as the Air India bombing of 1985 and the Lockerbie bombing of 1988 bear witness. So all these features of modern terrorism go some way towards explaining why special anti-terrorism laws may be necessary. But there are great dangers in such a generalized approach. To take an understanding of terrorism that is derived from history or social science and allow it to serve as a justification for any number of special legal powers is a dangerous course. However serious or unique the problem of terrorism, it does not follow merely from its seriousness or its uniqueness that special powers are necessary to combat it. If special powers are to be justified, it must be by reference to the particular demands of policing and prosecuting terrorism. So I propose to adopt a different approach. Looking at the various specific powers that our law now provides for dealing with terrorism, let us ask to what specific problems they are addressed. Some of them leave me baffled. Why, for example, should it be necessary to punish breach of a police cordon with up to 3 months in prison when the cordon was imposed around a suspicious package suspected of being related to terrorism, but with a maximum of 1 month when the suspicious package is of the common or garden explosive kind? More substantively, why is police bail available in appropriate cases to those suspected of violent crime, including some terrorists, but not to those arrested under the Terrorism Act 2000, however minor their alleged involvement? I've never met a lawyer who didn't understand that. I've never met a politician who did. But most of the rest can be linked to two operational requirements. The first is a perceived need, in a phrase equally beloved of football managers and spies, to defend further up the field, a consequence of the destructive potential of single concentrated terrorist attacks, the dangers of allowing such a plot to run, and so the resulting need to intervene at an earlier stage. The second is the need to rely on intelligence that cannot be disclosed, either from abroad, from human intelligence sources, or from technical surveillance. The first of those features, defending further up the field, is, I think, behind most of the elements of our terrorism laws. There is a whole range of special criminal offences whose effect is to make criminals out of people on the periphery of plots. We already have, of course, the inchoate offences, attempt, conspiracy, what we used to call incitement, to criminalise behaviour that is a prelude to an illegal act. But these precursor offences go back further still. They penalise a range of actions that fall short of constituting attempt, conspiracy, or incitement. A few examples. Anyone with information which they know or believe could help prevent terrorism or apprehend a terrorist is under a duty to disclose it to the police. This statutory duty to tell what you know has been used to convict family members and associates of the 21/7 bombers and one of the Glasgow airport bombers. It is also much mentioned, or so it is said on the street, to encourage people to talk. Mere membership of a proscribed organisation is a criminal offence, as has long been the case in Northern Ireland, whether or not one has supported specific acts of terrorism. The 2006 Act, the one that changed the rules of the game, criminalised acts preparatory to terrorism, a way of catching the person who cannot be shown to be part of any conspiracy, but who has been sending equipment to insurgents in Afghanistan or assembling bomb-making ingredients in Northern Ireland. It also created offences for those who have published statements likely to be understood as an encouragement to terrorism or disseminated terrorist publications, whether in a bookshop or over the internet. It was made an offence, finally, merely to attend a place that a person knows is being used for terrorist training, regardless of what the person was actually doing there. The same justification lies behind the special stop and search powers that have existed where terrorism is concerned. The most widely used and the most resented of these was Section 44 of the Terrorism Act 2000, which allowed any person to be stopped in designated areas or on the rail network and searched for articles which could be used in connection with terrorism. Though this has now been repealed, the power to stop, examine and, if necessary, detain port and airport travellers under Schedule 7 to the 2000 Act still remains, and it is also exercisable without the need for suspicion. Its statutory purpose is to determine whether people are terrorists. In practice, it is valued also for its ability to contribute to the intelligence-rich picture of the terrorist threat. Defending further up the field means, in addition, that arrests may need to be made before the investigation is complete. So an arrest under the Terrorism Act 2000 requires reasonable suspicion of the commission, preparation or instigation of terrorism, but not of any specific terrorist act. And if the court agrees to give it to them, the police have longer to question the suspects, up to 14 days under the current law, down from a maximum of 28 days prior to 2011. The airline liquid bomb plot, which was intercepted before it was ripe, and which required a vast quantity of evidence to be assessed from a number of jurisdictions, provides a rare example of detention periods which ran right up to the 28-day limit before charging decisions were made. The ultimate example of defending further up the field, indeed so far up the field as to be outside the criminal justice context altogether, is PREVENT, a controversial programme of engagement, in particular with Muslim communities, whose objectives include responding to the ideological challenge of terrorism and ensuring that people vulnerable to terrorism are given appropriate advice and support. Also preventative in their attention are the most controversial features of our anti-terrorism laws, the constraints that the executive may place on people who are suspected or now believed to be dangerous terrorists, but who cannot be deported or placed on trial. Mark I, made possible by that controversial derogation from Article 5 of the European Convention, was Part 4 of the Anti-Terrorism, Crime and Security Act 2001, which provided for the indefinite detention of non-British nationals who were suspected of terrorism but could not be deported because of the risk of torture. 15 such men were kept in Belmarsh prison. In one of the most resounding blows for liberty in the global jurisprudence of the past 10 years, that regime was famously declared incompatible with the Human Rights Act 1998 by the Judicial House of Lords in December 2004. The Mark II constraint which replaced it was the system of control orders under the Prevention of Terrorism Act 2005. Between 2005 and 2011, a total of 52 control orders were imposed upon men suspected of terrorism-related activity and considered to be dangerous to the public. The men were not imprisoned, as had been the case under the previous regime, but were required to reside in a place of the Home Secretary's choosing. They were tagged, had curfews of up to 16 hours, and were subject to reporting obligations. Particularly in the later years, after no fewer than 7 had absconded, they were subject to further onerous restrictions on where they could go, who they could meet and talk to. Almost half of them were subjected to involuntary relocation to another city, so as to separate them from their former associates, what the NGOs described as internal exile. At the start of that period, all were foreign nationals. By the end, all were British. So the focus shifted from the undeportable to the untriable. The last controlled persons were British citizens who had either been acquitted of terrorist offences or had never been put on trial because the Crown Prosecution Service had advised that there was insufficient evidence capable of being deployed in open court for a jury to convict. Though control orders were executive orders imposed by the Home Secretary, they required the prior permission of a judge and were subject after imposition to a quasi-automatic process of review by the High Court. In most cases, though not all, the courts upheld both the control orders and their individual components, including, in all but 4 cases, the relocation requirement. These measures defended up the field, in the sense that they sought to neutralise the threat from people who were thought still to pose a terrorist threat to the population. In that regard, they had some success. At any rate, no controlled person was ever detected engaging in terrorism. But they are also a response to the second problem that I mentioned, reliance on intelligence that cannot be disclosed in open court. The views reached by the Home Secretary could potentially derive from a number of sensitive sources. Human agents, whose cover had to be retained and personal safety ensured. Foreign intelligence agencies concerned as to how their information would be used. Technical surveillance. And lastly, phone tap evidence, which controversially is not admissible in a United Kingdom criminal court. Some of these men had been put on trial and acquitted. It was said because some of the intelligence that could have established their guilt could not be divulged to them or to a jury made up of members of the public. Others had not been put on trial for the same reason. By resorting to control orders, and indeed their less onerous Mark III successor, TPIMs, these difficulties were bypassed. The High Court heard reviews and appeals so far as possible in open court, but the national security evidence against the controlled person, which was generally the heart of the case, was adduced in a closed material procedure from which the controlled person was excluded, his interests being represented so far as possible by a security-cleared special advocate who could see the secret evidence but could not take instructions on it. Similar issues arose in relation to the freezing of the assets of a suspected terrorist in circumstances where this was deemed necessary to protect the public, either by order of the UN or the European Union or on the initiative of the Treasury. So those were the principal features of our anti-terrorism law, at least as it stood until recently. I've tried to indicate how most of the major elements of that law can be linked to a special characteristic of terrorist crime, whether it be the need to intervene earlier than would normally be the case so as to preempt the possibility of a catastrophic incident, or the difficulties of turning national security intelligence into evidence admissible in open court. This enables a more nuanced defence of the law than the oversimple argument that terrorism is a scourge and that special measures are therefore justified to counter it. But the fact that a specific operational objective is being pursued does not mean that each measure operates in a just or acceptable manner. Indeed, with such broad powers, the potential for abuse is rarely absent. Take the precursor offences. By seeking to extend the reach of the criminal law to people who are more and more on the margins, and to activities taking place earlier and earlier in the story, its shadow begins to loom over all manner of previously innocent interactions. The effects can, at worst, be horrifying for individuals and demoralising to communities. A well-known example, though thankfully not a typical one, is of Rizwan Sabir, the University of Nottingham student who in 2008 downloaded the Al-Qaeda training manual from the US Justice Department website in order to research his choice of thesis, and found himself detained for several days by the Nottinghamshire police, along with a university employee, on suspicion of the commission, preparation or instigation of acts of terrorism. He eventually won his action for false imprisonment, and I'm glad to say he continues to flourish in academic life. The proscription of national separatist organisations may be justified as a way of preventing fundraising. But as I've recounted in my report, it can also impinge upon the everyday life of those who are not members of the organisation, but merely of the ethnic community from which that organisation derives its support. Contact in the form of overt surveillance, evening visits at home from the police, and persistent pressure to inform, as one Tamil put it to me, shapes what it is possible to say. Silence silences those who take up one position and emboldens those on the other side. Added to which, condemnation by the United Kingdom as a terrorist organisation can be of useful propaganda value, both domestically and internationally, to governments which seek to repress the organisation in question or the population that it claims to represent, perhaps by violent and unsavoury means of their own. With control orders and now TPIMs, the severe restrictions on everyday life are coupled with a procedure for judicial review that is not only imperfect because of the subject's inability to see evidence against him, but unavoidably slow in its operation. Were it ever to be unscrupulously exercised, and I do not suggest that it has been, people could be detained under excessively strict controls for appreciable periods of time without any proper basis for doing so. My concern for the purposes of this evening is not whether these various powers are properly operated or whether their use can be counterproductive or indeed effective. That is for my regular reports. But I do want to ask what mechanisms exist to restrict the operation of the anti-terrorism law to those situations where it is properly required on operational grounds. The obvious place to start, perhaps, is with the definition of terrorism. Surely it may be thought if the concept of terrorism is defined with sufficient rigour, the special laws will be applied only where that is merited, and much of the potential for abuse will be removed. The problem of defining terrorism is a notoriously tricky one, made more complex by the intractable international dimension. Just 2.5 weeks after 9/11, on the 28th of September 2001, the United Nations Security Council issued a binding resolution under Chapter 7 of the United Nations Charter, number 1373, requiring all states to criminalise the funding of terrorism, to freeze without delay the assets of terrorists, and to take the necessary steps to prevent the commission of terrorist acts. But the implementation of this and other resolutions was hindered by the fact that there was and is no internationally agreed definition of terrorism. There are certainly ingredients, the dozen or so multinational conventions that outlaw specific acts such as hostage-taking, hijacking and terrorist financing, and the non-binding Security Council Resolution 1566 of 2004, which builds upon them. But there is far from being a consensus in the United Nations, which has been trying to draft a comprehensive convention on terrorism since 1996. Disputes over whether to acknowledge state terrorism and whether national separatist movements of any kind should be exempted from the definition suggest that attempts to devise a category called terrorism tell us more about the categorizer than what is categorized. Nor has international jurisprudence yet been able to provide a consensus. The Special Tribunal for Lebanon in 2011, chaired by Professor Antonio Cassese, identified what it considered to be a customary international crime of transnational terrorism and applied it in interpreting domestic terrorism offences under Lebanese law. But its conclusions had been highly controversial. In the absence of binding international definitions, individual states have not been slow to fill the vacuum. In his new book, Liberty and Security, Professor Conor Geraghty cites the definition adopted in October 2011 by the Standing Committee of the National People's Congress of China as follows: activities that severely endanger society, that have the goal of creating terror in society, endangering public security, or threatening state organs and international organisations, and which, by the use of violence, sabotage, intimidation, and other methods, cause or are intended to cause human casualties, great loss to property, damage to public infrastructure, and chaos in the social order, as well as activities that incite, finance, or assist the implementation of the above activities through any other means. As the Global Legal Monitor of the Law Library of Congress explains, this remarkably broad definition was defended by the Chinese government on the basis that the previous absence of a clear definition had hampered international cooperation in anti-terrorism efforts. Countries all over the world were given by 1373 a new and respectable weapon for fighting separatist or nationalist movements within their borders, be it Tibet, Chechnya, Kurdistan, or Tamil Eelam. An international obligation, no less, to prevent terrorist acts, coupled with the liberty to define terrorist acts in whatever way they wanted, and to attack not only those who take up arms, but those who promote ideas. After all, does not the United Kingdom punish the glorification of past or future acts of terrorism with up to 7 years in prison? The proviso that such glorification is illegal only when likely to be understood as an inducement to terrorist acts is a subtlety sometimes lost in the translation. In such ways, the language of terrorism may, as Professor Geraghty says of one Russian statute, provide both rhetorical cover and a strong legal basis for the continuation of the old habits of an authoritarian political culture. Martin Scheinin, the UN Special Rapporteur, reported in 2009 that counter-terrorism laws are being used in a number of countries to justify the arrest and persecution of homosexuals, to attack human rights defenders, and to suppress the claims of indigenous groups for social, economic and cultural rights. Small wonder then that the UN High-Level Panel on Threats, Challenges and Change noted that the norms covering the use of force by non-state actors have not kept pace with those pertaining to the use of force by states, reported that the absence of a definition of terrorism undermined the moral stance against terrorism, and called the adoption of such a definition a political imperative. The United Kingdom's definition has been influential. Lord Lloyd took his inspiration from a working document used by the FBI. The resulting definition in Section 1 of the Terrorism Act 2000, as amended, has been influential on others, particularly in the Commonwealth, but also at the level of the European Union. There are 3 elements to the definition, each of which must be satisfied. The actions, or threats of actions, that constitute terrorism, which encompass serious violence against a person, serious damage to property, and actions which endanger life, create a serious risk to health or safety, or are designed seriously to interfere with or seriously to disrupt an electronic system. So that's the actions. The target, secondly, to which those acts must be directed, in short, to influence a government or international organisation, or to intimidate the public or a section of the public. And thirdly, the underlying purpose that must be present, advancing a political, religious, racial or ideological cause. There is plenty of room for argument about how that definition is formulated. I want to look at those arguments not in the abstract, but in the light of their ability to minimise the potential for abusive use of our anti-terrorism laws. In relation to the prohibited actions, one might question the emphasis on property damage. The 1999 UN Convention on Financing of Terrorism speaks only of an act intended to cause death or serious bodily injury, words which, according to the Canadian Supreme Court, conveyed the essence of what the world understands by terrorism. Countries such as Canada and New Zealand only include property damage when it is likely to result in serious harm or risk to persons. However, since it is nowadays rare to encounter a plot which is aimed solely at damaging property, the point is, I suspect, of little significance to the manner in which our own laws are applied. One might ask whether serious violence against the person sets the bar too low. Cases of serious violence against the person are heard every day, in every Crown Court in the land. The view could be taken that special arrest powers, precursor offences, and so on are only really justified in a case liable to lead to mass atrocities, or at least the murder and maiming of innocent civilians. This could make a difference, but one must be careful what one wishes for. In particular, to restrict persons to civilians would remove from the scope of terrorism much of what currently goes on in Northern Ireland, vicious but targeted attacks on police officers and other representatives of the state. In relation to target and underlying purpose, the radical question is whether these conditions are required at all. For the historian or the psychologist, it may well be part of the essence of terrorism that it has a target other than the immediate victims, and perhaps a political purpose as well. But from an operational point of view, it's difficult to see why these factors should be relevant. After all, the ability to defend further up the field is justified, if at all, by the potentially lethal effects of terrorism, rather than by the mental element behind it. If a mass hostage-taking is on the cards, what matters from the operational point of view is what the perpetrators plan to do and what is necessary to stop them. Whether their motives are personal, financial, or political, whether they seek to influence the government or to intimidate people other than those that they've captured, are questions which may be of significance to their ultimate sentence, but which scarcely seem to have much bearing on the availability of precursor offences or the Terrorism Act arrest power. The point is underlined by the specific anti-terrorism conventions governing hostage-taking, hijacking, and so on, some of which require no mental element at all other than that which is inherent in the performance of the prohibited act. And even by our own Terrorism Act 2000, which provides that where the chosen means of attack is firearms or explosives, the requirement of an intention to influence or intimidate others does not apply. Particularly controversial is the requirement of underlying purpose, which is used by all the old Commonwealth countries and recently survived challenge in the Canadian Supreme Court, but does not feature in any of the UN definitions, the EU definition, or the formulation of the Lebanon Tribunal. Some believe that it has the undesirable effect of focusing on a defendant's religion or politics, chilling free speech, prolonging cases, and even encouraging racial or ethnic profiling by governmental authorities. As Professor Kent Roach has put the point, the political, religious, or other motives of the perpetrators should not excuse terrorism. Conversely, they should also not constitute part of the crime of terrorism. Such arguments have been considered in the past and may have to be considered again. But one should have no illusions as to what their effect would be. The target and purpose requirements in our current law have the function not of expanding, but of restricting the definition of terrorism. To remove even just the motive requirement could put our courts in the sort of difficulties recently experienced by the New York Court of Appeals, struggling to avoid affixing the terrorism label to a gang shooting aimed at intimidating Mexican Americans in the Bronx. As the court nobly held in a classic application of the age-old principle, I know it when I see it, the concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. Change along these lines would do nothing, therefore, to guarantee the limited application of our special anti-terrorism laws. On the contrary, it would expand the area for discretionary enforcement. The most striking feature of our definition of terrorism is that it captures actions taken against all the governments in the world, irrespective of their nature. As the Court of Appeal has explained, the terrorist legislation applies to countries which are governed by tyrants and dictators. There is no exemption from criminal liability for terrorist activities which are motivated or said to be morally justified by the alleged nobility of the terrorist cause. Whether directed at our government or that of Syria, whether an evil attack on civilians or a reaction to extrajudicial murder by the state, terrorism is terrorism. We might wish it otherwise, particularly in regard to separatist struggles where one would prefer not to have to take sides. But Parliament in the 2000 Act tried and failed to come up with a workable system for distinguishing freedom fighters from terrorists, and the Court of Appeal has also, unsurprisingly, declined the invitation to do so. In any event, since the great majority of terrorism prosecutions in our courts concern actions threatening the UK, the consequences of such a change would be limited. A linked issue is whether the definition of terrorism should be read as excluding acts which occur in armed conflict and are lawful according to the laws of war. Such actions are specifically excluded from the reach of the terrorism laws in Canadian, New Zealand and South African law. An amendment to that effect is also being considered by a senior Australian review body, which will report shortly. Such an exclusion would remove from the scope of the criminal law a man such as Mohammed Gul, the law student who posted videos on YouTube showing attacks on Allied forces in Iraq and Afghanistan, and was convicted of the offence of disseminating terrorist publications with intent to encourage acts of terrorism. The Supreme Court has been asked to imply just such an exclusion into the law. Mr. Gul's case will be heard there later this year. So amending the definition of terrorism, while possibly desirable in some respects, is never going to guarantee our anti-terrorism laws against abuse. One frequently suggested change, the removal of the motive requirement, would actually increase rather than reduce the scope of the laws. Others, a narrowing of the range of actions capable of constituting terrorism and a possible exemption for lawful actions in the course of armed conflict, could have beneficial effects in some cases, but will leave the great majority untouched. What then are we left with as a means of control? Just two things, as it seems to me. First, the need for wise exercise of some very broad discretions by decision makers: the police, the Home Secretary, the Crown Prosecution Service, the Director of Public Prosecutions, and where it is wished to prosecute offences allegedly committed abroad, the Attorney General. As my predecessor Lord Carlisle said in his essential report on the definition of terrorism, the exercise of such discretion is a precious and key exercise, and the heaviest responsibilities lie upon those in whom it is vested. But principally, we have to rely on constitutionalism, the checks and balances supplied by our unwritten constitution. It's neither fashionable nor wise to congratulate ourselves as a country, save perhaps on the organisation of international sporting events. But in relation to anti-terrorism law, under the extreme pressures of the past 12 years, the case can be made that our constitutional controls have not worked so badly after all. Parliament resisted giving the executive the sort of sweeping powers that enabled all aspects of the American war on terror to be run from the White House. It did not swallow everything it was asked to accept, voting down, for example, the proposal for 90-day detention in 2005 and 42-day detention in 2008, and making significant amendments, particularly in the House of Lords, to bills concerning asset freezing and TPIMs. Its committees, increasingly influential and impressive, provide an increasing degree of meaningful scrutiny. The courts have faithfully enforced the law, but also succeeded in improving it. Having declared detention in Belmarsh to be incompatible with human rights, the courts, abetted by an active legal profession, knocked many rough edges off the control order system and insisted that the asset freezing rules be properly compliant with the rule of law. They have demonstrated the wisdom in our constitutional settlement of a Human Rights Act that gives them the power to warn but not to override. Without, I hope, being too controversial, I unhesitatingly include the European Court of Human Rights in that appreciation. Its interventions have been few but important. In Gillen and Quinton, it gently administered the death blow to a stop-and-search power that, though used over 250,000 times in the single year 2009, seems to be not very much missed. Let us hope that this case, which was supported by Liberty, is not an example of the sort of case which, in the words of the current judicial review consultation, has developed far beyond the original intentions of this remedy. And in the case of A, while accepting closed material proceedings, the Court of Human Rights insisted on the vital principle that where the liberty of the subject was at stake, he must be given sufficient information about the allegations against him to enable him effectively to instruct his counsel. Despite forebodings at the time, the upshot has been an improvement in the fairness of such proceedings, with only a very limited loss of capacity to impose control orders and TPIMs. It's possible to acknowledge that the United Kingdom has made many errors in seeking to reconcile those awkward bedfellows, terrorism and law, while still appreciating its capacity to do better. I end with the words of the distinguished American professor David Cole from an article entitled English Lessons. The UK's experience suggests that it is possible for nations to learn from their prior mistakes. Its response to Islamic terrorism today seems, at least in part, to be tempered by the lessons it learned in fighting the IRA. An irreversible downward spiral in rights protections is not inevitable. The learning process must, of course, be an ongoing one and does not by any means guarantee that mistakes will not be repeated. But it helps. Thank you.
Well, I'm afraid I'm a bit like the New York judge. I know it when I see it, and I know it when I hear it, and I dare say I speak for all of you in saying that that's been a brilliant lecture combining history, political science, and the law. But you're not done yet, David, because foolishly you've agreed to take questions. So I'm looking for hands in the air. Good, I see one. Two, because time is reasonably short, I'm therefore going to take them in threes. We have roving mics, and perhaps in time-honoured fashion, you'd say who you are and why you're here, starting with the gentleman here whom I know.
Sebastian Payne, University of Kent. Why I'm here, I don't know. I'll leave that to my host to explain that. But my question to David Anderson, or it's really, I suppose, a comment, but maybe you'd like to respond to this comment, where I agree with your observation that the exercise of judgment matters enormously. But you then couple that with your what I take to be your take-home point, or one of them, which is that the constitutional checks have worked well. And my comment is this, that maybe there are two discourses or narratives that go on. One in the public sphere, and very much with the judges, in which the constitutional checks manifestly do work. And then another sort of discourse, and this is surmise on my part, because the discourse I anticipate is in the executive, between the foreign secretary, the agencies, and I wonder if that discourse is very different from the sort of thing we hear in public and the judges. And the reason I speculate on that is, for instance, if you think of the Conservatives when they're in opposition, and their very vocal opposition to the surveillance state, and then the very same government within a few months or a year or so of occupying government introduced the Justice and Security Bill. And so I wonder, the sort of discourse, whether really it's right to say that the constitutional checks are working. How do we know? They certainly, on the evidence, don't look as if they are, judging by the Justice and Security Bill.
Okay, so that was a question to which a submission was added at the end. And there's a hand here, and then I'll go to the back. I saw a hand. I'll go to the lady sort of 4 rows in from the back, but here next, please.
Yeah, my name is Stephen Sondem, University of Essex. Given the degree of invasion on personal liberties and the likelihood of abuse of these anti-terrorism legislations, would you recommend a situation where, I'm talking particularly about the denial of bail, would you recommend a situation where in the event of an acquittal, the state should pay compensation to the suspect or the accused persons?
Very clear, thank you. Yes, and lady with the pen in her hand at near the back. And that will do for this round, and we'll probably have one more.
Ruth Davis, I'm a specialist for the Home Affairs Select Committee. David, I'd be interested in your opinion about the argument that's often cited that the introduction of intercept evidence or the admittance of intercept in court would go some way towards lessening the need for some of the more controversial special measures such as TPIMs. I just wondered if you thought there was any merit in that argument.
Okay. Well, I'll take those, if I may, in reverse order, because that way I'll remember Ruth's question again. Yeah, intercept as evidence. There have been, I think, 7 or 8 studies over the last 15 years on the subject of whether intercept evidence could be rendered admissible in our courts. This is phone tap evidence, and it's admissible in pretty much every other common law jurisdiction in the world, Ireland being the other major exception. And so far, I think 2 of those reports have been public, the others have been internal reviews. And so far, the answer has been, well, it's probably possible, but it will be so expensive in terms of how we have to reorganize the security service and so on, that it's not going to happen. I still consider it's extremely desirable, as I think everybody does. But is it going to make the difference in these TPIN cases and these other cases with closed material procedures? No, I don't think it is. Very senior Old Bailey counsel wrote a very long opinion. It's probably secret. I'm not allowed to tell you how many pages it was, but I can tell you it was a lot of pages. In about 2008, when he looked at all the 9 people that were then subject to control orders, specifically in order to work out whether the admissibility of intercept evidence would have enabled them to be put on trial. And he concluded that it wouldn't have enabled any of them to have been put on trial. In, I think, 4 cases, because there wasn't intercept evidence that would have persuaded the jury. And in the other 5 cases, because the intercept evidence would have been extremely valuable, but there is no way the government would have allowed it to go into open court. And my predecessor, Lord Carlisle, I mean, I'm not a prosecutor. I have never done the exercise myself. I wouldn't be competent to do it. But my predecessor, Lord Carlisle, looked, I think, at all 52 control order cases. And what he said in one of his reports is 51 of them he was quite satisfied that intercept evidence wouldn't have made any difference. The 52nd he thought it would, but once he'd discussed it a bit with the Home Office, he decided that actually it was true of all 52. So I suspect it's not a silver bullet, although it's obviously very desirable, and not only in terrorism cases, but in organised crime cases as well. So far as, is it Stephen, and the question, you talked about people who didn't get bail, and you talked about compensation. What was that for, specifically, that you...
Well, it appears when you were giving your presentation,
Yeah.
You did mention that the anti-terrorism law permits the security personnel, officials, to detain people for a certain period of time without bail.
Yes.
Yeah, so my question is, if at the end of the day,
Yes.
the person is acquitted, would you recommend in the law that there should be provision for payment of compensation?
Yes. Well, I mean, if he was charged and then acquitted, then I think it was proper to detain him because a charging decision had to be made. If, on the other hand, he's not charged and there was no proper basis for the detention, then he's in the position of Rizwan Sabir. And he got off his backside, he sued the police, he walked away with £20,000. And that probably was the right result. Very interesting question from Sebastian about the way governments change when they come into office. And I think the suspicion from outside is always, oh, well, they've gone native or they've been got at by people. I can only speak from what I had observed. I came to this world completely new a couple of years ago. And the first thing I would say is that I've been more impressed than I expected to be by the Home Office. Now, they might not speak like somebody from Matrix Jones or Bernbeg Pierce, but they do at least speak the language of human rights. You know, they understand the compass of the debate, and they approach their job in an extremely professional way. If you see, for example, what I said about the way they prepare the control order files and the TPIN files for the Secretary of State, it is scrupulously fair. I always try and catch them out, spot some bit of counsel's advice that they didn't properly transmit to the Home Secretary. It never happens. They take it very seriously. But I appreciate that there are higher levels than that. And my sense, and again I've said this publicly in my reports, I think there are aspects of our counter-terrorism rule which are extremely political. And I would take the example of proscribing terrorist organisations. I can't help feeling that the utility of proscribing some little-known organisation in a far part of the world for the fight against terrorism, certainly in this country, or in relation to UK nationals, is very small indeed. But very often it's important for some other government that we do it. And it doesn't have to be the US or Israel. It could be quite a small place where the minister's going on a visit, and it would be nice to be able to say, don't worry, we found whatever route it is that you don't like. And I'm afraid I think that is partly why it's used. It's a very cheap way of doing foreign policy. You know, I've recommended some changes to that system. I'm still waiting to hear whether the recommendations are going to be accepted. In terms of the influence of the service, and let's not forget our liaison partners, as they're called, well, of course it's there. And of course they have something to do with the Justice Security Bill. And if you've read what I've written about this and what I've said in evidence, I actually buy the idea that we do need a closed material procedure for a small number of cases, so saturated with secret material that there just isn't going to be a fair way of trying them otherwise. And I do think there are advantages in everything being before the judge being able to write an open judgment and a closed judgment, and coming to the right decision on the case. I think there are powerful forces at work, no doubt about it. All I can say is that from my perspective, and I'm pleased and proud to say this, the powerful forces are just as much on the other side of the debate when you look what a strong NGO sector we've got in this country and how well organised they are, and you compare that even with a place like the Netherlands, very liberal North European democracy, where, as I am informed by the people I've spoken to there, most of the NGOs receive government funding. It's part of the deal that they don't attack the government or don't take the government to court. I think we're very fortunate. So yes, I think there are strongly held views. There are bitter disputes. We're seeing one of those at the moment on the Justice and Security Bill. But I'm afraid I don't buy the conspiracy theory that the whole thing is a stitch-up and that we're all run by the spooks.
All right, now I'm going to try and squeeze in one last round, which may be difficult because there's more than 3 hands up there. Where are the mics? First, the gentleman halfway up beside the aisle here, and then I'll go to this gentleman here at the front, and then to the back. Okay?
You have, I think, just touched on this, so forgive my pursuing the question. But in a case in which special counsel is appointed for a defendant, and that defendant cannot see or hear the material or evidence relied upon by the Crown for reasons of security, can justice be achieved in such a case and be seen to be achieved?
Over here. At the front.
Christopher Barnett, retired circuit judge, sorry.
You've lost your companion. No, it's, can we have a mic over here, please? And say who you are.
Thank you. Tom Hickman, barrister. David, I have 2 connected questions. They are, first of all, if there had been a derogation necessary to have control orders and TPIMs, we would be asking the question, are they absolutely necessary? And I think it's a legitimate question to ask in any event. Are control orders and TPIMs absolutely necessary? And the connected question is, what is it that justifies control orders and TPIMs now that didn't justify them in 1996 and in the period before 2005?
And then at the back, that side.
Thank you. David, I'm Patrick Doris. When I was growing up in Belfast, much later than Michael, I might add, as we now know from the Prime Minister, elements within the security forces were defending so high up the field as to be very firmly playing offence and using many of the same tactics that they were supposed to be defending against. Having spoken to a wide range of legislators in this kind of area, do you think that for them the most compelling basis for allowing a culture of exceptionalism to arise around terrorism is the fear that security forces will otherwise create that culture without legislation and without the attending oversight?
Okay, well, I'll start again at the end. I think that's absolutely right, Patrick. In fact, that's the point I meant to make. That if you're looking for another justification for all these laws, somewhere in the mix may be what is the alternative. And have we, by giving ourselves these laws, enabled ourselves to avoid the terrible mess they've got into in America, where the judges have largely abdicated their responsibility to review what the executive does in relation to national security. And it's probably an exaggeration. When you look at the readiness that they will accede, for example, to state secrets doctrine and so on, you do see that maybe some of these powers are a price that is worth paying also for that reason. And I think even within the powers, if you talk to someone like Shami Chakrabarti, she has never got too upset or excited about the precursor offences. Yes, they have an ability to interfere with people's freedom of speech and freedom of expression and so on, but at least they're getting a criminal process rather than being stuck on some executive order. So yes, I think there is that overlap there. Second question, what justifies control orders and TPIMs? Well, yes, the derogation wasn't necessary under Article 5, so as you point out, Tom, it was not necessary to pass that test. But you still ask very reasonably, what is it about these people that makes them more dangerous than their equivalents of 1996, or that means it's suddenly become necessary to lock them up? And my report on TPIMs will be coming out in a couple of weeks. And what I've tried to do in that and I'm not sure how many people really understand that, is I've read the open judgments in all the TPIM cases, and I've simply written a paragraph or two about each of the 10 men who are currently subject to TPIMs. And you'll know that at least 3 of them have been acquitted. One of them was acquitted of participation in the liquid bomb plot, the one that I mentioned. Had it succeeded, and it was a credible plot, would have exploded several transatlantic airlines. Another was never put on trial for involvement in the same plot. And there are other dangerous people. Were the dangerous people around in 1996? Yes, certainly there were. I think we've become less tolerant of risk than we were then. Preparing for this lecture, I watched the BBC video from 1996 where the chief constable came in after the South Key bombing, probably stood just outside this building, and he said, well, we try our best, but of course we can't keep London completely safe. It's inevitable there are going to be incidents like this. And I couldn't see that tone somehow being adopted by a chief constable today. And I think the third thing to mention, and it's the unmentionable word in a way, but I think you have to mention money as well when it comes to controllers and keepers. You probably have some idea, again, it's not something one's able to talk about, but you probably have some idea of how extraordinarily expensive it is to keep someone under a high degree of surveillance. And you probably also remember that when control orders were scaled back into TPIMs and relocation was ended, the police and the security service were given a huge, again, frustrating, the sum isn't known, but they were given a huge sum of money to compensate them for the fact that they would have to exercise more surveillance and couldn't rely on such long curfews and couldn't rely on relocation and so on. I think, to be brutally honest, yes, if you had surveillance teams, 3 shifts throughout the day, you could keep an eye on highly dangerous people, it would be so vastly, vastly expensive that no one would afford to do. The control order on the TPIM is a way you fit them with a GPS tag, you give them a curfew, you know where they are, and the consequence is that keeping them under control is easier. But let's not forget, it has to be necessary under our own domestic test to impose a TPIM, and every condition of that TPIM has to be necessary. And the courts, as you know, from time to time, will decide that a condition was not necessary, and they have decided from time to time that control orders weren't necessary. Does it give you a fair hearing? Well, there are 2 special advocates in the room, and I'm pretty sure they give you the answer no. And I'd also give you the answer no. I don't see how a hearing can be fair, fully fair, when the special advocate, although he's seen all the evidence, is not in a position to take instructions on it. And all I can say is, hats off to the Court of Human Rights, because where our own top court didn't quite dare do it, they went a bit further and said, well, an absolute basic requirement here is that the subject of this order knows the gist of the case against him. And at least if he knows that, and if he has enough to enable him to instruct his counsel, then we're prepared to say it's fair enough, given the extraordinary difficulties of a system in which you would never allow secret information to be known to someone who is suspected of involvement in terrorism. So I think that's probably the best I can do, unless the special advocates want to come in and give you their version.
The first rule of good chairing is not to stand between an audience and its liquid refreshment, but equally the quality of the questioning has been very high, and I know there were some other hands raised. I think I will take 2 more if they are there. I've already got 3. I'm only going to take 2, and I think it's in this aisle. Gentleman at the back and the lady further front, they both had their hands up for some time. David isn't disappearing anywhere soon, and I'm sure he'll be happy to have a natter to any of you who'd like to follow up afterwards. So it's just 2 this time. Gentleman at the back first. And questions, please.
Thank you. Thank you for your talk. Can I just quarrel slightly with your assertion that Robespierre was included with the other terrorist anarchists, etc., etc.? I'll just point out that Robespierre was actually democratically elected MP for Arras at the time. However, a minor detail. I'd like you to comment on the following, which is that there is an anomaly in the whole issue of terrorism regarding employment in the public service. Before, there used to be an assertion by the government that nobody could be employed in the civil service who had been a member of the Communist Party or of a fascist organization. And that's all been scrapped. It's been replaced by a so-called CTC, counter-terrorism check. And the CTC asks on the form, have you ever been involved in an attempt at the violent overthrow of parliamentary democracy? Yes or no? And then it says, you may still answer yes. Every application will be treated on its merits. Right? This is the current situation. That also includes people who are or have been members or supporters of so-called prescribed organizations. So I'd like you to comment on that, please.
Okay. And then further forward, please. And this is very much the last one.
My name is Stella. I'm from a campaigning organization, Campaign Against Criminalizing Communities, and that was established in 2000 with the implementation of the Terrorism Act 2000, and was formed in the parliament with affected communities who were on the terrorism list. At the time it was 19 organizations. And I want to specifically ask about proscribed organizations in terms of any kind of way that the criteria in the course of the challenges of the court of particular organizations, like from the Kurds and the Tamils and others, they have all lost. And they are still proscribed, although they were challenging this in court, on and off. Yeah, like the LTT, like the Kurdistan Workers' Party, via individuals and groups and organizations in Europe and the UK. So my question is really, what, in every case, it was not clear what were actually the criteria for proscribing the organization. And if you ask a member of any of the communities today, they still wouldn't know, where, at what level is this being discussed, who is making the decisions, is there any oversight, is there any process which you see possible that could be established to find out, who makes the real decisions for proscribing an organization, and how it can be challenged in open court. Can it be challenged at all?
Okay, thank you.
Okay. Well, I didn't wish to offend the sea green incorruptible by suggesting he was a terrorist, but I do think he presided over the terror between 1793 and 94. So on that basis, I brought him into the debate. Interesting points you make about civil servants. For me, the thing to watch there is a case of Tariq, which was decided by our own Supreme Court a couple of years ago. It was someone, I think, employed at the Home Office, who was told he couldn't go any further because his security vetting wasn't coming up very well. But beyond that, he wasn't told anything. And he said, well, I should have the same gist that these people on control orders have, particularly because I have European Union rights as well as my human rights. And the Supreme Court said no. But my understanding is that the Strasbourg Court has declared his application admissible, so there is going to be some argument there about whether this principle of gisting should extend beyond cases where people's liberties are issued into something like an employment case. Stella, as far as prescription is concerned, I would agree with you that I don't think the system is satisfactory, but I think it is pretty clear what tests they apply. First of all, they ask about the organisation, has it been involved in terrorism-related activity? And there are various sorts of terrorism-related activity, so they will look at all the evidence they've got, and they will decide whether as a matter of historical fact that is true. They will then ask, the second test is it necessary to protect the public in any country in the world that this organisation be proscribed? And they have various pointers to look at, like are they threatening British interests, are they active in the UK? But the killer is the fifth one. And I think in many cases the fifth one is actually the important one. And that's the one that says, I can't remember exactly, but it words along the lines of, does prescription help support an ally in the global struggle against terrorism? In other words, would someone else like us to do it? And I think that's where there is the potential for abuse. Legal challenge, only one has ever been taken to the tribunal, and it's incredibly time-consuming and expensive. People's Mujahideen of Iran. You needed expert witnesses who were able to say what was going on in that part of the world at a particular time. The issue was, had they renounced terrorism? And in the end, they won. The tribunal said that they had. I think the hearing took 3 weeks, and then there was an appeal, and luckily they were a very well-funded organisation, and I think perhaps they got legal aid. but it's not really practicable. And for that reason, I think we need something more. And just as an asset freeze only lasts a year and then has to be renewed, I think the minimum that ought to be done is that after a period of time the prescription should lapse. And if the Home Secretary really believes that there's still a case for proscribing that organisation, she will have to come back to Parliament with the evidence and present the case again. As I say, whether they accept that or not, I don't know. I'm conscious, a lot of Northern Irish expertise here, that these questions play in a very particular way in Northern Ireland.
Thank you. Well, look, I do think we need to bring the formal proceedings to an end. David, you bookended your comments by referring to the Canary Wharf bomb in 1996. This building hadn't been built then. If it had been built then, it certainly would not have withstood that blast, because this is the point closest to the South Quay station. There was a postscript to that in that this firm, when I was a partner here, was approached by Colin Parry, whose son was one of the two boys killed in the Warrington explosions, which numbers of you may remember in the early 1990s, to say, would Clifford Chance facilitate a meeting between him and Gerry Adams, because Gerry Adams had asked to meet him. So, and that engagement did take place in this building. And that was another occasion on which the meaning of terrorism was discussed. I don't mean that glibly, but one of the most impressive features of your lecture, David, is the way in which at all points you've sought to contextualize the discussion in hand, and we're very grateful to you for that. Please stop a while before you go home. I'm assured the quality of Clifford Chance catering is as fine as it was in my day. I reckon the audience is split broadly 50-50 as between Essex students, and we're particularly delighted to see them, and distinguished practitioners. And I think it would be nice if the practitioners spoke to the students and assured them, in case they were concerned to the contrary, that all professional colleagues in the law are a delight and are uniformly reasonable, that clients are sophisticated and understanding and always follow one's advice, and that there's nothing ever tedious in the practice of the law. So if you could do that on your way home, I know the students would appreciate it, but otherwise would you please thank our rather brilliant lecturer in the usual way.